I welcome members to the 32nd meeting in 2013 of the Delegated Powers and Law Reform Committee. We have apologies from John Scott. As always, ask members to turn off mobile phones. Agenda item 1 is a decision on taking business in private. It's proposed that the committee takes items 7 to 10 in private. Item 7 is consideration of the committee's draft report on the Procurement Reform Scotland Bill. Item 8 is consideration of the committee's approach to its consideration of the Agricultural Holdings Scotland Act 2003, Remedial Order 2014 Draft, Scottish Government 2013-261, and Statement of Reasons, Scottish Government 2013-262. Item 9 is consideration of a draft of the committee's second quarterly report for the parliamentary year 2013-14. And finally, item 10 is consideration of the Scottish Government's response to the committee's report on instruments considered by the committee during 2012-13. Does the committee agree to take these items in private, please? Thank you very much. Brings us to agenda item 2, which is instruments subject to negative procedure. The Health Board's Membership Scotland Regulations 2013, SSI 2013-334. Regulation 5 revives the Health Board's Membership and Procedure Scotland Regulations 2001 as they existed immediately before being amended by the Health Board's Membership Scotland Regulations 2009 in respect only of Fife Health Board and Dumfries and Galloway Health Board. An effect of this is to revive various outdated and repealed provisions as to the circumstances in which a Health Board member is disqualified from being such a member, and which are contained in Regulation 6 of the 2001 regulations. The Scottish Government has confirmed that this revival of outdated provisions is intended in the interests of consistency with the position for the other regional health boards. The committee may consider, however, that it is not satisfactory in principle that an instrument laid in Parliament should incorporate outdated provisions or omit suitable updating provisions. The committee may therefore wish to welcome the Scottish Government has undertaken to review and amend the 2001 regulations in the first half of next year as part of a planned stakeholder engagement to strengthen the governance and accountability arrangements for all health boards in Scotland, and that it will write to health boards before the 31st of December 2013 to give them notice of the upcoming consultation on updating the regulations. The committee may also consider that updating regulations should be laid as soon as practicable, so that suitable provision is made for the circumstances when a health board member should be disqualified from being a member. Does the committee agree to draw the regulations to the attention of the Parliament on the general reporting ground? Does the committee agree to welcome, however, that the Scottish Government has undertaken to review and amend the 2001 regulations in the first half of next year, and that it will write to health boards before the 31st of December 2013 to give them notice of the upcoming consultation on updating those regulations? Thank you. Agenda item 3 is instruments not subject to any parliamentary procedure. The Bovine Viral Diarrhoea Scotland Amendment No. 2 Order 2013, SSI 2013-337. The form or meaning of the definition of current BVD finding incited by Article 3A of the instrument in the Bovine Viral Diarrhoea Scotland Order 2013 could be clearer when read with the existing definition of BVD finding in the 2013 order. This discrepancy between the two definitions results in ambiguities in the provision made by the 2013 order as amended by this order. Does the committee agree to draw the instrument to the attention of the Parliament on reporting ground H? There is also a patent error in Article 17 of the instrument, which amends Article 24.1 of the 2013 order. Article 24.1 concerns maintenance by the Scottish ministers of a record of information notified to them under various provisions of that order. Article 17 of the amending order amends Article 24.1 to include reference to the 4 new requirements to notify matters to the Scottish ministers. It incorrectly refers to information notified under Article 23D2C, where the intention is clearly to refer to information notified under Article 23D1B. Does the committee therefore agree to draw the instrument to the attention of the Parliament under the general reporting ground, as there is a patent error in Article 11 of the instrument, Article 17, which amends Article 24.1 of the 2013 order? Okay. The committee may wish to note, however, that the Scottish Government has undertaken to lay an amending instrument to remedy both these matters. It is intended that the amending provisions shall also come into force on the 1st of January 2014, together with the provisions of this order. Does the committee therefore agree to note the Scottish Government has undertaken to lay an amending instrument to remedy both these matters? We do. Thank you. No points have been raised by our legal advisers on the Defamation Act 2013, Commencement Scotland Order 2013, SSI 2013-339, nor on the Sexual Offences Scotland Act 2009, Commencement Number 2, Order 2013, SSI 2013-341. Is the committee content with these instruments, please? Yeah. Thank you. Agenda item 4, the Landfill Tax Scotland Bill. This item of business is consideration of the delegated powers provisions of this bill after stage 2. Members will have noted that the Scottish Government has provided a supplementary delegated powers memorandum and will have seen the briefing paper. Stage 3 consideration of the bill is due to take place on Tuesday the 17th of December. The deadline for lodging amendments is 4:30 tomorrow, the 11th of December. The committee may therefore wish to agree on its conclusions today. Does the committee agree to report that it is content in principle with the amended powers at section 11.1, 13.4 and 17.1 of the bill, and with the parliamentary procedures which these powers are subject to? Okay. Section 35 permits the tax authority to delegate the exercise of any of its functions under the bill to SEPA. In its report at stage 1, the committee strongly recommended that delegation of functions to SEPA should be published. This recommendation was adopted by the Finance Committee. This point has not been addressed at stage 2, but the Scottish Government have committed to reviewing the matter in the context of the forthcoming Revenue Scotland and Tax Powers Bill. Does the committee therefore agree to reconsider the matter afresh once the Revenue and Scotland Tax Powers Bill is before the committee for stage 1 scrutiny? Thank you. Agenda item 5, the Bankruptcy and Debt Advice Scotland Bill. This item of business is consideration of the Scottish Government's response to the committee's stage 1 report on the Bankruptcy and Debt Advice Scotland Bill. Members have seen the briefing paper and the response from the Scottish Government. Do members have any comments, please? No, it seems not. Are we content to note the response and, if necessary, reconsider the bill at stage 2? Sorry, after stage 2. Thank you. Agenda item 6 then is Regulatory Reform Scotland Bill. This item of business is consideration of correspondence received by the Scottish Government in relation to the Regulatory Reform Scotland Bill. Members have seen the briefing paper and the correspondence from the Scottish Government. Proposed powers in section 10 and schedule 2 of the bill allow Scottish ministers to redefine and regulate new environmental activities. In its stage 1 report on the bill, the committee noted that regulations made under section 10 and schedule 2 are proposed to be subject to the negative procedure in all cases, except where they propose to textually amend an act. The committee expressed some concerns whether the procedures proposed in relation to the powers in section 10 and schedule 2 provide for full and adequate scrutiny of the regulations in all cases. It recommended the Scottish Government should fully consider in advance of stage 2 in which circumstances the exercise of powers would be more appropriately scrutinised by means of the affirmative procedure rather than the negative procedure. Having considered the committee's concerns, the Scottish Government has indicated that it does not consider it appropriate that any regulations made under section 10 should be subject to the affirmative procedure. However, in response to the committee's concern, the Scottish Government has proposed that ministers should provide periodic reports on the operation of Part 2 of the Act, with emphasis being placed on the environmental provisions it contains. The Government considers that such reports would give both the Parliament and the Government the opportunity to scrutinise the operation of the Act, and in particular the environmental powers, with a view to determining whether further procedural provisions are required. Do the committee have any comments on that, please? No. Do members therefore agree to welcome the Scottish Government's proposal the ministers provide periodic reports on Part 2 of the Act? Does the committee agree to write to the Scottish Government recommending that the production of such reports should be made a requirement which is set out on the face of the bill? We do. Thank you. Right, that completes agenda item 6, which brings us to the end of the public part of the meeting. We therefore continue in private. Thank you.